The long-awaited judgment was delivered by 7 justices of the Supreme Court, including Chief Justice Alfonse Owin Dollo, and decisions by Justices Naiti Pasetu Haise, Faith Monda, Mike Chibita, Monica Mugenyi, Catherine Bamgemereire, and Elizabeth Musoke. In delivering the decision, the Supreme Court justices elaborately tackled the historical perspective to military courts, tracing their origin from colonial rule, but quickly noted that most had modified their operations. The Chief Justice Alfonse Owin Dollo ruled that sections 197(1) and 2 of the UPDF Act contravene Article 129(1) and 126(1) of the Constitution, making them unconstitutional.
I hereby find that sections 2, now 1, 179, now 177, and 119(1)H, now 1171H of the UPDF Act are unconstitutional insofar as they, without qualification, allow for trial of persons subject to military law for civil offences within the General Court Martial and other military courts tribunals.
Other guarantees of justice and fairness in criminal proceedings are the right to a fair trial and the right to a fair hearing as stipulated under Article 28(1) of the said Constitution. I agree that Section 1171H of the Act is to be found void for vagueness and therefore inconsistent with Article 28(1) of the Constitution.
In addition, court ruled 119H G of the Act, which allowed the civilians to be tried by the court-martial for allegedly aiding and abetting, was also unconstitutional.
Judicial power in Uganda is exercised by the courts of judicature, and such subordinate courts as Parliament may by law establish. The court-martial system established under Section 197 of the UPDF Act is therefore one such subordinate court. I would declare that Section 197 of the UPDF Act, which establishes the General Court Martial, is not in breach of the Constitution. However, it is an overreach when the UPDF Act creates an offense that targets persons not otherwise subject to military law, making them criminally liable before the court martials for offenses of aiding and abetting. For creating such vulnerability, I would declare Section 117, which it is now, and Section 1171H, 1177 of the UPDA Act unconstitutional. I would set aside the decision of the Constitutional Court in this regard.
The 7 justices who individually made their ruling criticized the court-martial for lacking constitutional safeguard necessary for independence and impartiality required by courts of law under Section 128.
General Court Martial and other military courts are disciplinary organs of the UPDF whose jurisdiction is limited by Article 210B to handling matters related to discipline and removal of members of UPDF.
The persons selected to perform the functions of judges in military courts must display integrity and competence and show proof of the necessary legal training and qualifications, and military judges should have a status guaranteeing their independence and impartiality, in particular vis-a-vis the military hierarchy.
Justice Monica Mugenyi said the composition of officials presiding over the General Court Martial lacks legal profession and knowledge to conduct any court proceedings, and proposed that the court should be comprised of civilians appointed by the JSC rather than military officers.
These observations, I find that Section 2, Section 119, 1A to H, and Section 179 all grant jurisdiction to the General Court Martial and other military courts, which is inconsistent with Article 209A and 210B, and therefore, to the extent explained, unconstitutional and null and void.
Courts martial are not in a position to deliver a free and fair trial as guaranteed under Article 28(1) and 44 of the Constitution of the Republic of Uganda.
Justice Naiti Haise observed that whereas the GCM is reorganized as subordinate court, it does not have clear structures, guidelines on jurisdiction, and what judgment they are capable of making, pointing out that their jury undermines its fairness.
It is to be noted that both the General Court Martial and the Courts of Judicature, particularly the superior courts, under the respective laws that govern them, as well as the penal laws, either in the exercise of their original or appellate jurisdiction. It is also noted that under Article 123B of the Constitution of Uganda, the Director of Public Prosecutions, who is the officer charged with the function of, among others, instituting criminal proceedings against any person in that court, is exempted from instituting such criminal proceedings in a court-martial.
Court also observed that the military court does not have any judicial independence, which can be seen by their nature of oath and appointment.
The interests of justice and fairness require that any court that is empowered to pass a penalty for as serious as a death penalty, or even, I dare say, imprisonment, should be presided over by competent persons with legal qualifications. The jury, the competence and capacity of that court to handle criminal trials would still be questioned.
In a 200-page ruling, court ordered all pending files in the General Court Martial to be transferred to the Directorate of Public Prosecution's office.
I would forthwith suspend all operations of courts martial, save for the hearing of disciplinary matters pertaining to serving officers. All convictions and sentences passed by courts martial would be suspended.
The provision of Section 197, now 195, of the UPDF Act establishing the General Court Martial as a competent court is constitutional. 3. The General Court Martial created under Section 197, now 195 of the UPDF Act is a subordinate court of law but with specialized jurisdiction.
I'm Ivan Juko and Deborah Namamonde for UBC.